There is a moment in the life of every system built on rules when it stops being theoretical and becomes physical. When the architecture of authority that exists on paper, in statutes, in precedents, in the accumulated weight of centuries of legal tradition, must suddenly demonstrate whether it can hold when the person standing in front of it decides that none of it applies to him. That moment, in ways that most people watching the news cycle have not fully absorbed, is unfolding right now. Not gradually, not metaphorically, physically. In a courtroom in Manhattan where the exits are being watched with a new kind of attention, and where a judge is doing something that no judge in American history has been forced to do in quite this way, at quite this scale, with quite these consequences attached to the outcome. I have been watching legal proceedings for a long time. I have watched defendants who were angry, defendants who were contemptuous, defendants who believed the system was rigged against them and said so loudly. And in every single one of those cases, there came a moment when the weight of the room settled, when the reality of the institution pressed down hard enough that even the most defiant person in that space understood, at some instinctive level, that there were walls here that could not be argued away. That understanding is the foundation on which the entire structure of judicial authority rests. And what is happening right now is that foundation is being tested in a way that legal scholars are describing not as a crisis, but as the crisis. The one they always knew was theoretically possible and never believed they would actually live through. The headline reads like something from a movie that screenwriters would reject for being too on the nose. A man who has spent decades running away from accountability, who has treated every legal proceeding in his life as a negotiating table from which he could simply stand up and leave when the numbers stopped working in his favor, is now in a room where the judge has the legal authority to order the door sealed. And the question that is hanging in the air of that courtroom, heavier than anything any witness could testify to, is whether the person who walks in as a defendant walks out as someone who finally encountered a wall he could not buy his way around, delay his way past, or delegitimize his way through. To understand why this specific moment is different from every previous moment in what has been an almost incomprehensibly long series of legal confrontations, you have to understand something about the architecture of how courts actually work. Because most of what the public sees from courtroom proceedings, the motions, the rulings, the dramatic objections, the appeals, the delays, the procedural maneuvers that stretch timelines across years, all of that is the surface layer. The part that happens when everyone in the room is operating within the system's framework, even when they're fighting hard against its conclusions. There is a different layer underneath, a layer that almost never gets activated, a layer that exists precisely because the people who designed this system understood that one day there would be someone who refused to stay within the framework at all. And they built tools for that day that are not procedural. They are physical. When a judge in a federal criminal proceeding determines that a defendant is attempting to leave, not metaphorically, not in the sense of filing motions to delay or attempting to transfer venue, but literally standing up from the defense table and moving toward the exit, the authority that comes into play at that moment is not the authority of legal argument. It is the authority of the United States Marshal Service. Federal officers who are not politicians, who are not subject to public opinion, who are not running for anything, and who have exactly one job in that moment, which is to ensure that the proceeding continues and that the defendant remains present for it. The judge does not need to deliberate, does not need to consult with colleagues, does not need to issue a written opinion explaining the legal basis for what happens next. The exits get sealed, the marshals move, and the question of whether any defendant, regardless of who he is, regardless of how many supporters he has, regardless of what security detail surrounds him, is going to physically walk out of a federal criminal proceeding against the express order of the presiding judge, gets answered in real time. Now, I want to stop here for a second and ask you something directly, because I genuinely want to know what people watching this think. If you were in that courtroom right now, watching this unfold in real time, watching the tension between judicial authority and someone who has never in his life accepted the idea that any authority was legitimate if it ruled against him, what would you think is more likely to happen? Does the system hold, or does political reality bend the rules one more time? Write your answer in the comments. I'm going to read every single one. The appeals court, ruling that reduced the civil fraud penalty, was seized upon and declared a total and complete vindication. A definitive proof that the entire legal enterprise had been politically motivated from its inception. That messaging went out to millions of people and was received exactly as it was designed to be received, as confirmation of a narrative that had been carefully constructed over years and that required only the occasional friendly headline to maintain its structural integrity. But the legal reality underneath that messaging is considerably more complicated than the political packaging suggests, and the gap between those two things is where the actual danger lives, because the fraud finding itself was explicitly preserved. The appeals court reduced the penalty amount under an analysis of constitutional proportionality, but it left completely intact the judicial determination that financial records had been manipulated, that valuations had been inflated and deflated according to what was convenient at the moment, and that the people receiving those documents had been misled about the nature of the assets they were evaluating. That finding does not disappear because the penalty attached to it was reduced. It sits in the judicial record with the same weight and the same legal force it had the day it was entered, and it creates exposure in ancillary proceedings that the announcement of total victory conveniently does not mention. Declaring victory over the penalty reduction while the underlying fraud finding remains permanently on the record is the legal equivalent of celebrating that you successfully negotiated down the fine while the court's determination that you did the thing remains etched in stone. The stone is still there. The words on it have not changed. And in a criminal proceeding, where the standards of evidence and the stakes attached to findings of fact operate on an entirely different framework from civil litigation, that stone becomes the kind of foundation on which prosecutors build structures that are considerably harder to walk away from than a civil judgment. The pattern of behavior that produced the courtroom walkout, the raised hands, the loud declaration of departure, the Secret Service agent scrambling to follow a defendant who had just decided in that moment that he was done with the proceedings, that pattern did not begin with this case. It is the through line of a behavioral history that stretches across decades of business disputes, regulatory investigations, political controversies, and personal confrontations. In every single instance, the response to an unfavorable development followed the same architecture. Challenge the legitimacy of the process, attack the credibility of the people running it, delay as long as possible while the other side exhausts its resources or loses its patience. And if none of that works, simply leave. Walk away from the table. Declare the other party unreasonable. Move on to the next thing as if the unresolved matter behind you does not exist. That architecture worked brilliantly across decades in environments where the other parties lacked the one thing that makes it irrelevant, which is the coercive authority to compel continued engagement regardless of one preference. A business negotiation partner can be walked away from. A journalist writing a critical story can be sued into exhaustion or simply ignored. A political opponent can be delegitimized until his supporters erode. But a federal judge ordering marshals to seal the exits of a courtroom cannot be walked away from. There is no negotiating move available at that point. There is no motion to file. There is no press conference to hold. There is only the physical reality of a room with sealed exits and federal officers whose job is to keep them sealed. What makes this situation genuinely unprecedented in American legal history? What gives these conversations among legal scholars a quality of tension that I have not heard before in academic legal discussion is the presence of a second set of federal officers in that room whose authority comes from an entirely different source and whose mandate creates a potential conflict that has no established resolution. The Secret Service agents assigned to protect this individual are not there because a judge ordered them to be there. They are there because federal law requires them to be there, and their obligation to their protectee does not contain a clause that makes it subordinate to the preferences of a trial judge or the orders of court marshals when those agents believe their protectee needs to move for safety reasons. In the scenario that legal commentators have been gaming out with increasing seriousness, you have two sets of federal officers, both operating legally, both following legitimate authority chains, both carrying out their institutional mandates as they understand them, and those mandates pointing in opposite directions in the same physical space at the same moment. The marshals have been ordered to prevent anyone from leaving. The Secret Service has been trained to move their protectee when circumstances require it. And the moment those two imperatives collide in real time, you have a constitutional confrontation that no court has ever had to adjudicate, for which no precedent exists, and whose resolution cannot be predicted from any existing legal framework. I want to ask you something else here, and I want you to think about this carefully before you answer. This is the deeper question underneath all the courtroom drama and all the legal maneuvering. Do you believe that in America in 2026, the rule of law still means the same thing for a politically powerful defendant that it means for anyone else who walks into a federal courtroom? Not rhetorically, not as a talking point, as a genuine assessment of the institutional reality you see around you right now. Write what you actually think in the comments, because this is the question that matters more than any particular verdict in any particular case. The political calculus around a forced courtroom confrontation runs in directions that are genuinely contradictory depending on which audience you are trying to reach. And the people whose job is to understand those audiences understand that the same image can produce opposite reactions in different rooms. For the most devoted supporters, marshals blocking exits and a judge ordering physical compliance with a court order would instantly become the most powerful persecution narrative imaginable. A literal visual of institutional power being deployed against a political leader who refuses to submit to a process his supporters already believe is corrupt. The fundraising response would be immediate. The rally energy would be enormous. The social media velocity would be unlike anything that had preceded it. But for a different set of voters, the suburban moderates whose mathematical weight in swing states is the actual arithmetic of electoral outcomes, that same image carries entirely different associations. Someone who tried to walk out of a federal proceeding and was stopped by federal officers does not look like a fighter being persecuted. He looks like a defendant trying to run from consequences and being physically prevented from doing so. Those are different stories. And the political advisors who count votes in places where the margin of victory is measured in thousands rather than millions know exactly which story plays in which room, and they are not comfortable with the trajectory of the current one. What is being stress tested right now, beneath the specific facts of this specific proceeding, beneath the penalty reduction and the fraud finding, and the gag order violations in the courtroom theater, is a question about the nature of institutional authority in a democracy where institutional legitimacy depends on something more fragile than physical force alone. Courts derive their authority not primarily from marshals and contempt powers, though those matter, but from a widespread social acceptance that judicial rulings deserve respect and compliance because they represent something more durable and more legitimate than the preferences of any individual, however powerful. When a defendant who commands the loyalty of tens of millions of people models consistently and publicly, the posture that courts are just another opponent to be fought and delegitimized and if necessary physically walked away from, the damage to that social acceptance does not require a successful escape to materialize. The modeling itself does the damage. The performance of contempt is corrosive, independent of its legal outcome. Judges presiding over these proceedings have been tightening their procedural grip with a visible and deliberate consistency. Gag orders issued, financial sanctions levied for violations, defense motions rejected with decreasing tolerance for procedural delay, rulings delivered with a firmness in their language and their framing that signals clearly to anyone who understands courtroom dynamics that the bench understands what is at stake for judicial credibility and how these proceedings are managed. Each of those tightenings has been a message, a signal that the accumulated pattern of defiance has been observed, documented, and is being accounted for in how the proceeding is being conducted. And each additional act of defiance, each gag order violation, each theatrical courtroom exit, each public declaration that the entire system is corrupt, each one of those accelerates the timeline toward a moment that cannot be resolved through a financial sanction. Because there is a threshold in the logic of judicial authority past which fines become meaningless, past which the only instrument of enforcement that remains is physical. And once you have crossed that threshold, the institutional response is not optional. A judge who permits a defendant to physically walk out of a federal criminal proceeding while cameras are rolling and reporters are watching has not just lost a procedural battle. He has demonstrated in the most visible and unambiguous way possible that the authority he represents can be defied without consequence by someone with enough political support and enough security detail to make enforcement difficult. That demonstration would be the end of something that took centuries to build and that cannot be reconstructed once the image of its failure has been seen by enough people. And here is the thing that I find most striking when I sit with this situation and try to understand what it means beyond the specifics of this particular defendant and these particular charges. The legal system has tools for this. It has always had tools for this. The marshals exist precisely because someone, somewhere in the history of this institution, understood that there would eventually be a defendant who believed the rules did not apply to him, and built into the architecture of the courtroom itself the physical capacity to demonstrate otherwise. Those tools have not been seriously tested at this level of political visibility before, but they exist, they are legal, they are constitutional, and the authority to use them does not require permission from anyone outside that courtroom. What I keep returning to, what I cannot let go of when I think about where this is heading, is the image of those doors. Not as metaphor, though the metaphor is obvious, but as a literal physical fact. A federal courtroom has exits. Those exits can be sealed by order of the presiding judge. And when they are sealed, the question of whether the person who stood up from the defense table and announced he was done, whether he actually gets to be done, gets answered not by public opinion or by political supporters or by fundraising numbers or by social media engagement. It gets answered by the physical reality of sealed doors and federal officers standing in front of them. The scenario being discussed by legal scholars is not science fiction. It is the logical endpoint of a trajectory that has been traveling in one direction for a very long time. A defendant who treats every legal proceeding as a political performance eventually encounters a proceeding where the judge decides the performance is over, where the order to the marshals is given, where the exits close. And in that moment, the entire superstructure of political messaging, the total victory declarations, the persecution narratives, the delegitimization campaigns, all of it becomes irrelevant to the immediate physical question of what happens next in that room. I said it at the beginning, and I will say it again here because I believe it is the truest thing I know about what we are watching. There is a moment in the life of every system built on rules when it stops being theoretical and becomes physical. We are approaching that moment faster than most people realize. And when it arrives, it will not look like a political debate. It will not look like a legal argument. It will look like a door that does not open. And on one side of that door will be a man who has spent his entire life finding exits. And on the other side will be an institution that was built deliberately and specifically for exactly this day. One last question, and this one is personal. I want to know where you are watching this from right now. What country, what city, what corner of the world found you sitting in front of this video thinking about American courts and the rule of law and sealed exits? Because this story is not just an American story. It is a story about what happens when institutional legitimacy meets political power. And that is a question that has no borders. Write it in the comments. Tell me where you are. Because the people watching this are part of something larger than any single legal proceeding. And I want to understand the shape of that thing. The doors of that courtroom are not just doors. They represent the answer to a question that this country has been circling for years without fully asking. Whether the principle that no one stands above the law is a genuine institutional commitment, enforced with the same tools and the same determination regardless of who the defendant is, or whether it is an aspiration that bends to political reality when the defendant has enough power to make enforcement uncomfortable. Every previous stress test of that principle has been resolved before it reached the physical. Before it reached the doors, before it required the marshals to move. This one is different. This one is headed somewhere the others did not go. And when it gets there, we will all learn something essential about where this country actually stands. Not what it says, not what it declares in its founding documents or celebrates in its national mythology, but what it actually does when the man walking toward the exit is powerful enough that stopping him has a cost. That is the test, and the result is not yet written.